So welcome everyone, and thank you for joining us this morning for what we hope will be an informative presentation for realtors in the city of Richmond. My name is Palomar Sanchez, and I'm a staff attorney and public information unit supervisor for the City of Richmond Rent Program. Housing Counselor Magali Chavez will be conducting this morning's presentation. Please note that this presentation has been posted on the website at richmondrent.org/workshops for your reference. If you have questions on a particular topic discussed today, we ask that you save your questions to the end during the question and answer period. And without further ado, Magali Chavez.
Hello, good morning, everyone. Thank you for joining us today. One note that I did want to make is that there is a Q&A section on Zoom. So if through the presentation you think of a question, you could always type it in. That way you don't forget it, and we'll get to it at the end. So let's get started. Okay, so one of the first things that we wanted to talk about, which is outside of the ordinance, but is an important community update. So everything right now that's going on with COVID, the Director of Emergency Services issued a resolution, or it's an eviction on a moratorium on evictions effective March 17th, and it was recently extended to July 15th. And what it means is that during the period of local emergency, no landlord may terminate a residential or commercial tenancy for non-payment of rent or for any no-fault eviction, which is owner move-in, withdrawal from the rental market, substantial repairs, or temporary tenancy. There is, for non-payment of rent, the tenant would have to notify the owner in writing within 30 days of the rent being due. So there are some notifications that the tenant has to do. In addition, an owner may not increase residential real property through July 15th. And the residential real property that is exempt from the rent control provisions of the Richmond Rent Ordinance is exempt from this section to the extent that such properties' rent may not be regulated under federal or state law. So some of these properties are single-family homes or Section 8 properties. So if you have any questions about the order, you can ask it at this Q&A, or feel free to contact the rent program and we can discuss it further in detail. Okay, so let's get started. So today we'll be discussing the purpose of the ordinance, the overview of the Richmond Rent Ordinance, what properties are covered under the rent ordinance. So this is important because not all properties are covered in the same way. Compliance with the rent program, compliance with eviction protections, and compliance with rent control requirements. We'll be giving some tips for realtors that we've seen throughout that are helpful or useful from the cases that we worked. A brief overview of the rent adjustment petition process, and a quick overview of important California civil codes. Okay, so let's get started. So the purpose of the rent ordinance, which its official title is the Richmond Fair Rent, Just Cause for Eviction, and Homeowner Protection Ordinance, which we'll refer to as a rent ordinance, is really to promote neighborhood and community stability, have healthy housing, and create affordability for renters within the city of Richmond. And it does so by controlling excessive rent increases and arbitrary evictions to the greatest extent allowable under California law, while it tries to ensure landlords have a fair return. So this is a quick overview of the rent ordinance. It was passed on November 8th of 2016. It went into effect December 30th of 2016. And the rent program opened its doors to the public on January 3rd, 2017. So let's get started for the Richmond Rent Ordinance. So the Richmond Rent Ordinance is not an all-encompassing thing. There are two sections that it breaks up into. The first section is rent control. What this means is that rents are regulated. The maximum allowable rent, which you'll hear referred to as a MAR, is calculated by taking the base rent and the annual general adjustments, which is referred to as a cost of living increase. This is usually what the maximum allowable rent is, but in addition, there could be allowable individual rent adjustments through the petition process, which is ordered by a hearing examiner. This is not usually the case, but that's what the MAR encompasses. So the base rent is essentially the rent that was in effect on July 21st, 2015, if the tenant was there at that time. If they moved in after July 21st, 2015, it would be the first rent that was charged for the tenants for the date that they moved in. And then also the annual general adjustment, it's considered 100% of the consumer price index in the Bay Area. It's also the inflation rate in the Bay Area. And then the petition process is really just a mechanism to increase or decrease the maximum allowable rent, also the MAR, under reasons permitted by the ordinance. So that's one section, which is the rent control section. And then the other section is just cause for eviction protections. What this means is that a landlord needs to have one of the 8 just causes to terminate tenancy. They cannot just arbitrarily evict a tenant. So if they want to start an eviction process, it needs to be under one of these 8 reasons. And we'll go over those reasons in further detail. So first, we're going to start with which properties are covered by the rent ordinance, because not all properties are covered the same. So the first is what are called fully covered properties. These are properties that are under rent control and just cause for eviction protections. And these are multi-unit properties that were built on or before February 1st, 1995. Then we have partially covered properties. These are properties that only have just cause for eviction protections. There are no rent controls whatsoever. And these is a variety of properties. There's subsidized units, which include Section 8 tenancies or low-income housing tax credit or affordable housing units. There are properties with only one dwelling unit on one parcel, and this is a very important definition because this is also what people consider single-family homes. Condominiums, and then new construction, which is properties that were constructed after February 1st, 1995. So I want to discuss the properties with one dwelling unit on one parcel because I think it's important. So a lot of people refer to these properties as single-family homes. But particularly in Richmond, there's a lot of properties that people consider single-family homes that have an additional dwelling unit. So the garage was converted, or there was an ADU added, or the house was subdivided. If that has occurred in the property, then it's potentially a multi-unit property, and it could fall under rent control. So I think it's important, I think, for realtors to be aware of that. And, if you're ever showing a property, or a new buyer or potential buyers looking at a property that has an additional dwelling unit, I would recommend that you check with the rent program, because if it does fall under rent control, there's obviously other restrictions that occur with the property and other things that could occur with the tenants. So that's one thing to note. And then there are fully exempt properties, which means that they don't fall under the rent ordinance whatsoever. They have no rent control and no just cause for eviction protections. And these are properties where it might be a rental, but the landlord and tenant share a kitchen and or bath. So if I own the home and I rent out a room, but me and the tenant share a kitchen and or bath, it's not regulated under the ordinance. Single-family homes where permitted ADU was added and the main house is owner-occupied. So that's important to note. The important thing here is that it's permitted as an ADU with the city of Richmond. And then the last one are retirement homes. So this is a quick guide that we've created for accessory dwelling units because it's a little bit confusing. And there could be different circumstances on whether the unit is permitted or not. So I'm not going to go over it. It's just kind of here for you to look over. If you have any questions, obviously feel free to call the rent program. The information is on there. Okay, so what is compliance with enrollment, registration, and fee payment requirements? The rent program has all these different requirements to be in compliance. So there are 2 important factors. One is enrollment and tenancy registration, and the other are the rental housing fee. So these are the basic minimum requirements that an owner needs to do to be in compliance. So the first thing is a property enrollment. if all rental units in the city of Richmond that are subject to the rent ordinance are required to enroll the property, regardless if they're fully covered or partially covered. So, you know, the new owner would get this form and they would need to fill it out and provide information on the property address and their own personal information. That way we have an updated record of the property owner. In addition, if the property is under rent control, the owner would need to register their tenancies. So this is only a requirement for rent controlled units, but this is also a requirement to be in compliance with the rent program. So that's an important thing to know if you're showing properties that are under rent control. And then there's the residential rental housing fee. So if you are going to be renting in the city of Richmond, there are several fees within the city, but the rent program has what's called the residential rental housing fee. And it works it runs through a fiscal year. So if you rent any time from July 1st, let's say this year of 2019 to June 30th of 2020, you would be required to pay the residential rental housing fee. And the fees are broken down from fully covered, partially covered, or government subsidized units. But essentially a fully covered or a rent controlled unit for this fiscal year was $212 per unit. And then partially covered or government subsidized units were $112 per unit. So the new fiscal year, the fees will probably be published sometime soon. But those are the requirements with the rent program. So you would need to enroll the property and pay the residential rental housing fee. So now for realtors, it's really important to understand that if you're selling the property or if you're helping somebody buy the property, they're potentially inheriting these fees. So realtors owe a fiduciary duty to their clients, right? So that duty includes a duty to act with reasonable care and diligence when facilitating a transaction. It also requires a full and fair disclosure of material facts. Payments owed, whether that be to the rent program, other city departments, or to tenants, are necessarily material as sellers want to be able to obtain the full benefit of the bargain. Failure to disclose excess rent may be considered material and lead to legal liability. So this is important because we get a lot of cases where like new owners will come in and the previous owner owed like thousands of dollars worth of fees. And so now the new owner was not aware that all these fees were owed, but that is something that they're not responsible for because the fees follow the property. So I think it's important to be aware of that fact and to obviously disclose that information or work with the owner to pay the fees before the property is sold. Okay, so now we're going to move forward with compliance with just cause for eviction requirements. So just cause for eviction applies to almost all properties within the city, with almost all rental properties within the city of Richmond. So if you're showing a rental property, it's important to understand the just cause for eviction requirements. So there are 8 just causes. The first 4, failure to pay rent, breach of lease, nuisance, and failure to give access, are what are called at-fault evictions, meaning that the tenant is doing something to produce an eviction, which, it's failing to pay the rent or breaching the lease. There are specific steps that the owner needs to take in order if they want to pursue an eviction. For failure to pay rent, obviously they would need to give them a 3-day notice. For breach of the lease, nuisance, or failure to give access, these evictions require what is called a written warning notice first. And there are several steps that the owner needs to take in order to fulfill those requirements under the ordinance. And then there are the other 4, which are, we call no-fault evictions, meaning that the tenants are not doing something wrong, like they're paying their rent, they're keeping up with their lease. It's just for those very specific reasons the owner wants to take possession of the property. And those are, temporary vacate in order to undertake substantial repairs, the owner move in, withdraw from the rental market. These 3 specific just cause for evictions require a relocation payment. So there's like the little asterisk there in the slide. If you have questions about that, there's further information on the website, or you could always call the rent program. And then the last one is temporary tenancy. That's if the owner established a temporary tenancy before they rented out the unit, and the house is their own primary residence and it's only partially covered. So those are the 8 just causes. So like how I mentioned before, the written warning notice is required for breach of the lease, nuisance, or failure to give access. So essentially, if you think the tenant is breaching the lease, creating a nuisance, or failing to give access, the first step under the ordinance is to give the tenant a written warning notice. And so the written warning notice has to include 5 things, but essentially what it does is it provides the tenant with the reasonable period of no less than 5 days to correct the violation prior to serving a notice to terminate tenancy. It must do these 5 things. It must state that failure to cure may result in an eviction. It must inform the tenant of their right to request a reasonable accommodation. It will include the contact number of the rent program. It will also include instructions for compliance. So what the owner wants the tenant to do to comply and correct this violation. And it will include information necessary to determine the date, time, place, and witnesses present and other circumstances at the time, so the tenant can have a full idea of what they were doing, what mistakes they did, or what is it that needs to be corrected. The rent program provides a template for landlords to use that kind of allows them to fill in the problems and like what the different information requires. And that's the link to the template if the owner would need it to, if there's a breach of the lease, nuisance, or failure to give access. Okay. So once the notices have been submitted, the rent program also has noticing requirements. So after the termination of tenancy has been given to the tenant, the landlord must submit a copy of the termination of tenancy with the rent program within 2 business days of serving the tenant, along with the proof of service. The termination of tenancy should be submitted online, and this is the link to the website. Failure to file the termination of tenancy notice timely may be asserted as an affirmative defense in an unlawful detainer. So like if the issue continues and the owner files an unlawful detainer, but they never submit the termination of tenancy notice with the rent program along with written warning notice if it was given, the tenant can say the owner was not in compliance, they didn't follow these requirements in court when they go through the unlawful detainer process. Okay, so that's essentially eviction requirements and the different requirements with the rent program. Now we'll move forward with compliance with rent control requirements. We're going to be discussing the maximum allowable rent, which is the MAR, the base rent, AGAs, and rent increase noticing requirements. All these different terms will apply to what are called fully covered units, which is rent controlled units. So to understand the way that rent control works, it's important to understand the way that the maximum allowable rent, or the MAR, works. So the MAR is essentially the maximum rent that can be charged for a controlled rental unit. I would think of this as kind of like the rent ceiling. A rent increase cannot exceed the maximum allowable rent, but it can be less. Even if the maximum rent is not charged, the maximum allowable rent remains the same. The landlord may choose to raise the rent to the maximum in accordance with state law and the rent board's banking regulations. So essentially, the MAR is a calculation of the base rent and the applicable AGAs. So you never lose your right to the MAR. It's just kind of something that is automatically calculated. So you can lose access to a higher MAR if there's a petition filed, but automatically it's the way that the base rent and the annual general adjustment works. So essentially, it's equals the base rent plus the annual general adjustments, which go into effect September 1st of every year. And then the individual rent adjustments, which are approved through the petition process. And this could be either a decrease or increase for the petition process. So the second part of the MAR is establishing the base rent. And this is a good example of how the base rent works. So under the rent ordinance, landlords were required to roll back rents to the rent level in effect on July 21st, 2015. Or the initial rent if the tenancy began after that date. So I think this is an important concept for realtors to understand. I've definitely had cases where someone is selling the property or someone has already purchased the property and the owner never rolled back the rent. So the tenant has claims to access rent, and it just creates like a messy situation where the new owner is kind of like, I had no idea that this was due, or the old owner was like, I sometimes the old owners don't know either, that they're not aware of, the different laws or how the base rent and the rolling back the rent works. So this is a good example. So let's say in September of 2014, my tenancy began and my rent is $1,000. In December of 2015, the rent is raised to $1,100. And in December 30, 2016, the rent ordinance goes into effect. But if we look at what the base rent is, on July 21st, 2015, the tenant, myself, I was paying $1,000. So in reality, my base rent is $1,000 because I was paying that on July 21st, 2015. Ideally, in ideal circumstances, on December 30th, 2016, my landlord rolls back the rent to $1,000, right? Because they recognize, like, okay, you're currently paying $1,100, but actually your base rent or what you're paying on July 21st, 2015 is $1,000. So they roll back the rent to $1,000. And then once, the ordinance goes into effect and all of the program is open on February of 2017, after proper notice, the landlord serves me and increases my rent, the rent allowed by the rent ordinance, which was 3% at that time. So now my rent is $1,030. The time that I paid $1,100 when the rent ordinance was not in effect, the owner does not have to give me that money back. They are, right, the ordinance wasn't in effect, so I was paying $1,100 at that time. But once the ordinance goes into effect, the owner has to roll back my rents, and they have to, establish what my base rent was, and then do the rent increases from here. So as you can see, that sometimes gets landlords in trouble if they had no idea that they had to roll back the rents, or if they raised their rent sometimes before the ordinance went into effect, but after July 21st, 2015. So I've definitely seen cases, especially now that we're 3 years into the rent program, where the landlord has continued, they never rolled back the rent, and they have continued to charge the tenant excess rent, and all of that adds up. In this scenario, the difference between $1,000 and $1,100 is $100 per month. That's $1,200 a year, times 3 is like around $3,600. And that's if they haven't charged me any other rent. So you can see how that'll quickly add up. I've seen Kate go in, sometimes in the tens of thousands of dollars. So it's very important to know this as a realtor. And, when looking at rent control property, understanding what the tenant's base rent was when they moved into the unit and what they're currently paying. So you can do that calculation and check if the owner is in compliance, and all their rents are properly in effect. So in addition to the base rent, the maximum allowable rent has the annual general adjustment. So the AGA is essentially the annual allowable cost of living increase. It's equal to 100% of the consumer price index, also known as the inflation rate. And it's announced by the rent board no later than June 30th. So, we're looking at announcing a new AGA this year, pretty soon. The AGA can be taken September 1st of every year, but one full calendar year must expire. So for example, I think this is a little bit confusing for some people. If my tenancy began in August of 2019, the owner can take my first AGA September 1st of this year, because from September 1st of 2019 to September 1st of 2020, I was a tenant and my tenancy was in effect for that whole year. But let's say my tenancy began October 1st of 2019. The owner won't be able to take the AGA September 1st of 2020 because there hadn't been a full calendar year that had passed. They will actually have to wait until September 1st of 2021 to take the AGA. So that's a little bit confusing and understandably frustrating for some people. Depending on when the tenancy began, they might qualify for the AGA or not. Okay, so the AGA can be taken on September 1st of each year after proper legal notice. So usually, like the rent program would start going into their what we call AGA season. The AGA is announced, at the end of June, and then from there, the owners start issuing their rent increase notices around end of July. So the tenants will have a 30-day notice, and the rent increase goes into effect September 1st. Right now, that's a little bit different because of the order that's in place. So that's going to push back the rent increases for rent-controlled units minimum until July 15th. Possibly further if the order gets extended. And then a common question is, can landlords bake AGA increases, or do I lose my AGA increases if I don't issue them every year? And so the AGA increases never get lost, so they're banked. So you can bank all your AGA increases, but there is a limit to how much you can increase within any given year. So a limit of 5% of previously deferred AGAs can be recovered each year, plus the current year's AGA. But rent increases may not be applied retroactively. So I'll give an example, but for more information, you can read the banking regulation 602. So let's say I've never given any rent increases for the past 3 years. I've qualified for 3 AGAs. So to make the math simple, the AGAs have been around 3% every year. So I have 9% deferred AGAs. And I also have the current year's AGA, which is 3.5% for 2019-2020. So I can take 5% of my previously deferred AGAs plus my current year's AGA, which would be 8.5%. But I'll have the other 4% still banked because I can't take it all at once. And the idea behind this is that the tenants don't get rent shock, right? So if like 10 years have passed and then the owner never gave a rent increase and then all of a sudden they want to do it at once, you're talking about a 30% to 40% increase all at once. So the banking regulation is the idea that the owner doesn't lose their AGAs, but they can't just, apply a huge rent increase at once. So that's the banking regulation. So these are the annual general adjustments. For 2016, it was 3%, 2017 was 3.4%, 2018 was 3.6%, and the last increase, which was effective September 1st of 2019, was 3.5%, and the new increase for 2020 will get announced, sometime in June. In addition to, qualifying for the annual general adjustment, the landlord must give the tenant proper notice of a rent increase. And this is California Civil Code 827. If it's an increase of 10% or less, it's a 30-day notice, and this will be the case for all rent-controlled units, but it applies also for non-rent controlled units. So if it's an increase of more than 10%, it'll be a 90-day notice. And you can look up Civil Code 827. So this is just an example of how the maximum allowable rent works. So as you can see here, the base rent started at $1,000, and every year it increased. So a tenant that was paying $1,000 is not paying $1,141.98. Also, as you can see, the AGAs are compounded, so they're multiplied on top of one another. So I think that's a good example to know how the MAR and the AGAs work. So there are requirements for taking an AGA increase. There are administrative requirements, and this is kind of compiling all the information that we previously talked about. So the landlord must be in compliance with all aspects of the rent ordinance, and this includes the property enrollment, registering tenancies, paying the rental housing fee, and then properly rolling back rents and refunding any overcharges to tenants. And then there are noticing requirements, which is they have to, after serving the tenant with the rent increase notice, they have to provide the rent program with a copy of the rent increase notice with proof of service within 10 business days of having served the tenant. So you would have to serve the tenant with the rent increase notice and a pamphlet or a brochure from the rent program, and then submit a copy to us within 10 business days. And as a quick reminder, this only applies to rent-controlled units. It does not apply to partially covered units. Partially covered units are not, their rent is not regulated by the rent program. Okay, so again, there's a disclosure of maximum allowable rents. So similarly to the residential rental housing fees, this is another area where we see that new buyers and sometimes realtors can get into, there's like different legal responsibilities. So as a disclosure, realtors owe a fiduciary duty to their clients. That includes the duty to act with reasonable care and diligence when facilitating a transaction. This duty also requires a full and fair disclosure of material facts. Failure to disclose any excess rent due may be considered material. So the failure to disclose reduced MARs is necessarily material, as the amount of money one is able to collect in rents determines the valuation of the property. So if the rental amounts are inaccurate and the seller knows of it, the seller may be misleading the buyer into a transaction that the buyer may not have otherwise engaged. This failure to disclose may lead to legal liability. So I've definitely seen cases, several cases, unfortunately, and especially around like the stop-go agreement, because sometimes the owner will give the tenant a stop-go agreement and it'll say this is how much the tenant is currently paying, and the seller will give that to the new owner. But just because that's how much the tenant is currently paying doesn't mean that's how much their legal rent should be, right? Because the tenant may be overcharged in rent. So that's why whenever we have new buyers, I think it's extremely important to understand how the MAR works, and kind of ask for a little bit more information when purchasing or consider buying a property, or even when you're helping someone facilitate that transaction, understanding that you need to know when the tenants moved in to understand when to calculate their base rent, which again was on July 21st, 2015. If they were there at that time, or if they moved in after, what they paid their first month's rent, and then from there taking the increases of the AGA. And then also sometimes there's petitions involved. So I've definitely seen cases where like the tenant has filed a petition for excess rent or habitability issues, and the owner sells the property. So now the new owner has inherited a tenancy and a property that has petitions. Where the decision hasn't been made yet, but the decision could be made that the previous owner owed money. So those are circumstances that are messy, and we wouldn't recommend. So we usually advise people to get a PRA, on the property, and that way they can understand, they can look at the notes from the rent program and all of the different documents that are involved in the property to have a better understanding of what's going on with the property as it relates to the rent program. So another question is, when can rents be raised to market? This is a very popular question. So essentially, there are 3 times that the owner can raise a rent to market. And one of them is when there's a voluntary vacancy and a new tenancy begins. So if you're under rent control and your tenants completely move out and you have new tenants, once that tenancy begins, you will be able to reestablish the base rent, and the owner is the one that, establishes the base rent. The second one is when all of the original occupants or leaseholders vacate and only holdover subtenants remain in the unit. So if that occurs, once you only have subtenants, the subtenants do have eviction protections, but you have the right to reestablish the base rent. And so you would be able to do that at that point. And it's very important to know when the people have left, because sometimes this can get a little bit messy if the owner has been collecting rent from the subtenants, but they've never reestablished the base rent. It could be interpreted that the new owner decided not to reestablish the base rent because they continue to collect that rent and have now established a tenancy with the subtenants. So we always recommend that if you're ever in that situation or have any questions, it's better to call us and be informed than kind of wait for the situation to occur and then 6 months or a year have passed and now you're in a situation that you might not want it to be in. And the third one is if the tenant no longer lives in the unit as his or her primary residence, and this sometimes occurs if there's a leaseholding tenant that is subletting the unit or is using the unit as a vacation home. So sometimes with rent controlled units, if they had previously been lived there and their rent was really low, and they're like, okay, well, I don't want to live here, but I don't want to lose the low rent, so they keep that rent or have their give it to their friend. There's different circumstances why that occurs. The owner can say, well, you're no longer using that unit as your primary residence, therefore you're no longer protected by rent control and are not entitled to that rent under rent control. And if there's disagreements, we do have a petition that the owner or tenant can file on, and a hearing examiner would establish what the proper rent should be. Okay, so let's move forward. So a little bit about vacancy decontrol and recontrol, which is essentially what controls the rents and what we refer to as establishing a new base rent. So vacancy decontrol and recontrol it comes from state law, which is the Costa-Hawkins Rental Act. I think that's, Costa-Hawkins. And essentially it's the way that rent control works under the state of California. So when my tenancy began in March 2015, the landlord and myself contracted that my rent was going to be $1,000, and the rent was going to include garbage, water, and also parking was included. So this is the owner establishing the base rent. We have come to an agreement that my base rent was $1,000. And unless the rent was increased from March to July, this was also my base rent on July 21st, 2015. So in 2016, the rent is increased by 3%. And then in 2017, the rent is increased by 3.4%. So now my rent is $1,065 with 2 cents. In 2018, or sometime before that, I decided to move out. And so a new tenancy begins, or myself, who was the original occupant, have vacated, right? So now there's a decontrol that occurs. And what this means is that the owner can establish a new base rent. So in 2018, the landlord resets the rent to $1,450 and contracts with new tenants, or this could be the holdover subtenants, and parking is not included. So that would be an additional fee that those tenants would have to pay. essentially, this is just kind of an example of how the vacancy decontrol and recontrol works. Okay, so these are important tips for realtors. It's just something that we've seen throughout time from counseling. So the first one I think is very important, understanding that the sale, transfer, or foreclosure of a property is not just cost for eviction. So we get a lot of cases where the owner is selling the property and they simply issue a 60-day notice to the tenant asking them to leave because they want to sell. And this is really important because it's not just cost to evict. Selling the property, there's no restriction from selling the property, but if you want to evict the tenant from that property, you need to have just cost for eviction. And similarly, for the new owner thinks that they purchased a property with the tenant in it, and sometimes they think that they can just evict the tenant, similarly issue a 60-day notice. And this is not the case. Both parties, whoever wants to evict the tenant, needs to have just cause for eviction. The second is that the new owner will inherit the tenants living in the property along with the existing stipulations in the written or verbal agreement. So this is an important one because I think sometimes new owners don't understand that everything that occurs in the property, they will be inheriting. So this means the residential rental housing fees. If there's any excess rent that was charged to the tenants, whatever the leases stipulate or lack of leases that there are stipulated. So when there's a lack of a lease, this could also be difficult because the tenants that have been there don't have a responsibility. They don't have to sign a new lease. So this creates different dilemmas because the previous owner ran the property a specific way, and now the new owner wants to run it a different way, but there are no leases. So there's no legal stipulations on how the tenants need to, what they need to do with the property other than, local or state law. So I've seen this happen a lot. Also, the new owner purchased a property and they have no idea what the base rent is. They have no idea what the current tenant is paying. So this is also like where excess rent issues occur, that either party or the old owners didn't provide that documentation, the new owner doesn't have it, and so the tenant is claiming my base rent is this, and I was paying this, you're charging me excess rent. But there's no easy way for the new owner to establish that. So I've seen that occur, and those situations can get messy really fast. And the third one is that if the unit is under rent control, the owner must abide by the maximum allowable rent or the MAR, even if the rent has not been rolled back and the tenant is owed excess rent. So this is another one where we've seen cases just get really messy. The owner thinks that they can, the new owner thinks that they can purchase the property and then charge the tenants whatever they want, especially if they're paying a much higher mortgage than the previous owner was. And so they calculate, what they can afford differently. And when they purchase the property, they have like this huge surprise that the tenants, their rent is not what they were expecting to be charged. So it can create like really difficult situations, both frustrating, both for the tenants, the new owner, and potentially the realtor or real estate agent. So we always encourage to call the rent program if you need any assistance understanding or calculating the MAR. But essentially it's the base rent, plus the annual general adjustment. You would need to know when the tenancy began, what they're paying when the tenancy began, or what they're paying on July 21st, 2015, and what they're currently paying to, have an idea to better calculate the maximum allowable rent. Okay, so moving forward, the rent program also administers what's called the rent adjustment petition process. So I'll briefly touch on this. I don't think it's an important detail. So there are tenant rent adjustment petitions. And so the tenant rent adjustment petition is a petition for excessive rent due to failure on the behalf of the landlord to roll back the rent, or for charging rent above the maximum allowable rent. So sometimes it's one, that the owner didn't roll back the rent, or two, that they charged an AGA higher than what they could have charged, or they charged it multiple times, or there's some type of discrepancy and what they think their maximum allowable rent is. So the tenant can always file a petition with the rent program and say, like, the owner has been charging me excess rent. And obviously the petition is similar. It's like an administrative process, and it's similar to court, where the tenant would file and then the owner would have the right to object to those claims. And, all documentation would go in front of the hearing examiner, and the hearing examiner would make a determination or decision, or both parties can agree on a settlement. The second petition is to reduce the rent due to decrease in space, services, and or habitability. So the idea is that the tenant's rent includes proper services, the idea to a habitable unit, and specific space. So at any point, then this is specific to rent-controlled units. The petition process is only for rent-controlled units, because the rent program can regulate the rent for rent-controlled units. So if the tenant is having habitability issues, or, like the owner removed their parking space for some arbitrary reason, any type of reduction in space or service or habitability, the tenant can file a petition and request that there be a reduction in their rent, because the idea is that the tenant has been overpaying because they are no longer receiving those services or that space, or, or the ability to live in a peace and quiet, or like in joyful, like if I have mold or something's leaking or something to that extent. So that's the petition for that. And that's also one that we commonly see, when this is an issue with new owner purchasing properties. The third one, and this one is the least common. I don't think I've ever counseled on one of these before, but it is a petition that tenants have an option to. So under the ordinance, tenants can replace their roommates on a one-to-one basis. So the idea is that if you have a 2-bedroom apartment, you pay $2,000 for the rent, divided, it's $1,000 each. If one tenant decides to move out, that rent that the tenant was paying, the now tenant that is occupying the unit should have the opportunity to replace that tenancy on a one-to-one basis. So now, there's no difficulty in paying that rent. If the owner, for some reason, unreasonably prohibits the tenant from replacing that tenant on a one-to-one basis, then the tenant can file a petition and say, you know what, like the owner has unreasonably refused me to replace that tenant, and I want my rent to be reduced by the percentage of people that it was reduced. So if it's 2 people in an apartment and one leaves, that's a 50% reduction. If it's 3 people in an apartment and one person leaves, that's a 33% reduction. So that is an option that tenants have. I've never seen a petition come through me, but it is an option that tenants have. The most common ones are excess rent and the reduction in space or habitability issues. The other petitions are landlord petitions. So landlords can petition to increase the maximum allowable rent due to increase in the number of occupants allowed. So vice versa, if let's say my base rent is 2 people, and I've always had I have like a 1-bedroom apartment, and I decide, like, the rent is too high, I would like to add another person. The owner can say, okay, you can add that 3rd person, but I'm going to petition for a rent increase. And so the ordinance allows up to a 15% increase for each additional person. That's usually, I think that would be the ideal way that it would occur. But there are situations where the owner will come to us and say, hey, like, I leased out to 2 people and now I think there's 5 people there. What can I do? And so they could file a petition. And there are exceptions. So you wouldn't be able to petition for family members, right? So like if it's a couple and the couple has a baby, you can't say like, well, their base occupancy was 2 people and now I want to charge an additional 15% for that baby. So there are restrictions on who are considered additional occupants and who can be charged excess rent, or not excess rent, I'm sorry, who could be charged additional rent for additional occupants. But that is a petition that is available. There is also petitioning to increase the maximum allowable rent due to increase in space or services. So the most common one is parking space. So if my tenancy began and I did not have a parking space, but now I just purchased a car, I can request that the owner adds a parking space, and the owner can say, okay, that's fine, but I'm now going to charge you, I don't know, $50 for the parking space. The owner still needs to file a petition with the rent program because it's an increase to the MAR. So they would need to file a petition, and the hearing examiner would do an administrative approval to make sure that it's commercially reasonable and both parties agree to the rent increase. If the owner does not file for that petition and the tenant has been paying for the parking space, it is possible that the owner will need to pay excess rent back. So that's an important thing to know, that anything when you're charging the maximum when you're charging above the maximum allowable rent, above what is allowed from the base rent and the annual general adjustment, requires a petition. The third petition is petition to increase the maximum allowable rent, also the MAR, due to increases in net operating costs. And this is what is considered a fair return under the ordinance. The idea of this is that the owner has a right to what they were receiving in net operating income from 2015. So the petition compares their net operating income for 2015 and adjusts it to inflation to what their net operating income is in 2019, because it works like taxes. So it would be a full year. So it would compare 2015 and 2019 if the owner were to file in 2020. This also takes into consideration capital improvements. So if the owner, has made a lot of repairs in 2019, they could file a petition and say, you know what, like my expenses are much higher than they used to be when they were in 2015. I would like to have the capital improvements considered along with like increases in fees or taxes or any costs. So if an owner who says, my expenses have, drastically increased, that might be an option that they could consider in filing an M&OI petition. Okay, so moving forward, we're going to discuss the overview of important California civil codes. I'm going to briefly go over them because there are a lot of detail, but these are the laws that intersect the most with the ordinance. So there's overall 6 laws that we constantly counsel on. So the first is the implied warranty of habitability, which is Civil Code 1941.1, and this relates directly to our petition process, and especially for rent-controlled units, how the rents are not calculated, but if the tenant is having habitability issues, they can make a petition. So the idea is that landlords must provide a property that is in habitable condition and fit to live in. Landlords must repair problems that make the property uninhabitable, except for problems caused by the tenant or the tenant's guests, children, or pets. In order for the property to be habitable, it must have like all of the following things. So generally, right, waterproofing, plumbing, gas facilities, heating facilities, working toilets, adequate trash receptacles. So there's obviously like a large list of all the things that the owner is responsible for in providing a habitable unit. The next law is 1941.2, which is similarly the tenant's responsibilities. So a tenant must take a reasonable care of the rented property in common areas such as hallways. This means that the tenant must keep those areas in a good working condition. A tenant must also repair all damage that he or she causes or that is caused by the tenant's guests, children, or pets. So I think this is an important one to know, especially for tenants. Sometimes they'll have guests over and like the guests will punch like a hole in the wall and they're like, well, that wasn't me. But you become responsible for those people when you let them into the unit. So that's important. And there's a list of things that they have to do. There's Civil Code 1950.5, which is security deposit law. And I think this one intersects with realtors if, there's a property, because the old owner, the previous owner, has to give the security deposit to the new owner. So I've definitely seen cases where the new owner has purchased a property, they don't have a lease, they have no idea what the tenant's security deposit was. The old owner, the previous owner, didn't give them any security deposit funds. So now this new owner has, a different amount of tenancies and potentially owes them security deposit to be paid out, or has no security deposit if there was damages done to the property. So that's usually how we see this security deposit law intersect. But essentially, the security deposit is any payment, fee, deposit, or charge imposed at the beginning of the tenancy and as an advance payment of rent, which is used to cover rent defaults or repairing damages caused by the tenant or cleaning. The first month's rent isn't considered a security deposit, but money paid in excess of the first month's rent is. So if you were to collect last month's rent or anything in addition to that, it would be part of security deposit. A security deposit may not exceed 2 times the monthly rent for an unfurnished unit or 3 times the monthly rent for a furnished unit. And it's important to know that for rent-controlled units, the security deposit that is established at the beginning of the tenancy is the security deposit that can be collected, because the security deposit is considered rent. So in the same way that that a tenant can petition for excess rent, the tenant could also petition if they don't agree with what the owner deducted in security deposit, or if the owner doesn't return the security deposit at all. Rent-controlled units can file a petition for excess rent for not receiving a security deposit or not agreeing with the deductions in the security deposit. So the landlord can deduct from the tenant security deposit only the amount that is reasonably necessary to cover rent defaults, repair damages the tenant or tenant's guest cause, other than normal wear and tear, and then do necessary cleaning, defined as the amount of cleaning needed to return the unit to the same level of cleanliness at the beginning of the unit. So essentially, how you give the tenant the unit, they're responsible for returning that unit in that same way. The other thing is that the tenants have a right to a walkthrough inspection no earlier than 2 weeks prior to the tenant vacating. The owner has to give proper notice unless the tenant waives this requirement in writing. The other important thing to note is that after the tenant moves out, the owner has 21 days to return the security deposit and any accounting that occurred. So the owner has to furnish the tenant with a written statement itemizing the amount of and purpose for any deductions from the security deposit, and return any remaining portion of the security deposit. And this is especially true if more than $125 is deducted. So I think this is the law. Civil Code 1950.5 is very specific on the security deposit, how the security deposit should be handled. So I think it's very important for owners to be aware of the steps that they need to take. And so the effect of sale and the deposit, a landlord who sells a rental property must either 1, transfer the deposit to the new landlord, or 2, return the deposit to the tenant. So this is sometimes where I see issues around the security deposit if there's been a recent purchase that the previous owner hasn't followed this. And the tenant's recourse deposit is if the deposit is not returned within 21 days of vacating. So like I mentioned, the tenant, if it's a rent-controlled unit, can file a petition with the rent program. But in addition, they can file in small claims court. And the benefit or the plus of small claims court is that they can file for twice the amount of a deposit for what is considered bad faith retention. So, if 21 days have passed and the tenant is messaging the owner and saying, hey, where's my security deposit? I haven't received it. And the owner's like, I'm not returning anything, or doesn't provide any documentation. The tenant can always make a claim that that was a bad faith retention, that the owner didn't have, wasn't interested or didn't want to follow that law. Obviously, it would be up to a judge to determine if that's bad faith retention, but that is an option that tenants have. Okay, so next law. This coincides with the security deposit law, but also just in general, lawful landlord entry, which is Civil Code 1954. Essentially, the owner cannot enter the property for any reason that they want. And then sometimes I will see this in leases that the owner has scheduled, continuous inspections, like they automatically do a 6-month inspection or a 3-month inspection, and that's not really, it could potentially be against Civil Code 1954, because the landlord may only enter to make necessary or agreed repairs, decorations, alterations, or improvements, to supply necessary or agreed services, or to exhibit the dwelling unit to prospective or actual purchasers, mortgagees, tenants, workers, or contractors, or to make an inspection under Civil Code 1950.5. So this is important to know, when you're exhibiting a property. The landlord must give the tenant written notice to enter at least 24 hours prior to entry. So that's also important. The landlord can't just say like, hey, I'm entering your property, and the tenant had no idea. The landlord does not need to provide a written or verbal notice in case of emergency. The tenant cannot demand that they be there when the landlord enters. So I think that's sometimes where tenants might get in a little bit of trouble. If the owner issues a 24-hour written notice and, they show up and the tenant's like, you can't enter my property, or the tenant's like, I'm not going to be there, so you can't enter. So the tenant doesn't have to be there. They can be there if they want to, but they have to make their own accommodations. Entry must be during normal business hours. So you can't say like, oh, I'm coming into your property at 2 a.m. at night. Here's a 24-hour written notice. The landlord must state the time and date as well as the purposes of the entry in the written notice. So that's important things to follow. It's also important to know that in Richmond, it is just cause to evict the tenant who denies a landlord lawful entry after the tenant has been warned to cease denying lawful access and continues to do so. So that's an important way of enforcement of this law. Like especially I think sometimes I hear around like exhibiting the unit that the owner's trying to sell. Maybe there's some type of conflict between the owner selling and the tenant just isn't allowing people to go inside and view the property, or is having issues with the realtors or, different people that are viewing the property. So that is an option that you have, is to issue a written warning notice and continue that process if that is a continuous issue. The last is, I don't know if so there's Civil Code 1946. So it's proper notice when terminating tenancies. And this doesn't apply as much to our ordinance, although it applies to some. But essentially for most no-fault evictions, landlords must give a 30-day written notice to terminate a tenancy if it's less than 1 year. And then under the same code, a tenant must give a 30-day written notice to vacate or to terminate their tenancy, and can give notice on any day of the month once the lease has converted to a month-to-month lease. Under Civil Code 1946.1, a landlord must give at least 60 days written notice to terminate a tenancy if the tenancy has lasted a year or more. So it's important to note that any termination of tenancy served in the city of Richmond must cite one of the permitted just causes for eviction, unless the rental unit is fully exempt from the rent ordinance. So that's what I mean by it doesn't, it applies, but it's not as straightforward as just issuing a 60 or 30-day notice to vacate, because you do need to have a just cause for eviction. And then this is an important one, which I've mentioned several times throughout the presentation, which is Civil Code 827, which is giving proper notices for change in terms of tenancy, which is usually given for rent increases. So generally changes in terms of the tenancy require a minimum of 30 days written notice. A notice to increase the rent by 10% or less requires a 30-day written notice of the rent increase. A notice to increase the rent by more than 10% requires a 90-day written notice of the rent increase. And the law just recently changed January 1st, 2020. It used to be 60 days, but it was increased to 90 days. So that's an important difference to know if you didn't already know. Okay, so the other one is 1951.2, which is the lease breaking law. So essentially, if a tenant breaks a lease, if they're on a 1-year contract and they're kind of like, I got fired or I got another job, and I've actually heard several of these cases going on right now because of COVID. So I got fired and I can no longer pay my rent, or I got a new job somewhere else. The tenant can break the lease, but they would be liable for unpaid rent remaining on the lease, but only if the landlord attempts to mitigate unpaid rent damages by making a reasonable effort to re-rent the unit. So another way to put it, if a tenant breaks a lease, the landlord cannot make the tenant pay for the remaining unpaid rent unless the landlord can show that they made a reasonable effort to re-rent and were still unable to find a replacement or new tenant. So that's an important thing to note, that if the tenant breaks the lease and just leaves, the owner, needs to consider, they can't just say, well, you have 6 months on your lease, that's how much you're going to owe me. Because the owner does need to make a reasonable effort to try to re-rent the unit and offer it to someone else. The idea is that they can't double dip, right? Like they can't rent out the unit a month later and then charge the previous tenant that unpaid rent and continue to charge this new tenant the rent. So that's kind of the idea. I think this is our last slide. Yes. So thank you so much for joining. I know it's a lot of information. It can be a little bit overwhelming. Moving forward, we're going to move on with our Q&A session. So myself and I think the staff attorney will also be listening to your questions. If you have any questions, please put them in the Q&A section in Zoom, and we can answer them one by one in an orderly fashion. Thank you so much for your time.
Thanks, Magali. So we have 9 questions in our Q&A box. So what I'll do is I'll go ahead and read them, starting from the first ones that were submitted onwards, and we'll have a chance to ask those questions. And if we don't get to all of the questions, we encourage you to contact us by email at rent@ci.richmond.ca.us, or our phone number, which is 510-234-RENT, which is 7368. But hopefully we'll be able to get to all of these. So let's get started. The first question is, if you have asked a tenant to remove a dog that is not allowed on the property, I assume this means conduct yard maintenance and make utility payments, would you consider these a breach of lease?
So, the rent program doesn't determine if it's a breach of lease or not. It would ultimately be determined in court by a judge. So I would recommend that you read over your lease, right? Like I'm assuming that the lease stipulates that there are no pets allowed. So it's important to understand what your lease says. The utility payment question is a little bit complicated because it depends if it's a rent controlled unit or not. So I don't know if you want me, I guess this is where it's a little bit difficult to answer that question for the utility payment. If it's not a rent controlled unit and it's stipulated in the lease that the tenants needs to not have pets, take care of yard maintenance and pay whatever utility, and they're not doing so, the first step would be to issue them a written warning notice. And then, if they don't comply with the written warning notice, then it would be to issue a termination of tenancy. However, I will caution you that this is going to involve an unlawful detainer process, and ultimately the only person that can determine whether it's a breach of the lease or not is a judge through the unlawful detainer process. So it's not a simple process, and it's not a straightforward answer. I don't know, Palomar, if you want to add anything.
Yeah, I was just going to add 2 things. One, it says to remove a dog that is not allowed, not necessarily a pet. So that's a question, right? That's a factual question that you have to find out, is like, is it a pet? Because dogs can actually be service animals. They can be emotional support animals. And those are not actionable issues if even if a lease says no pets, they're not considered pets. So it really depends. And you should probably talk, to an attorney if you are considering that as far as a breach. Second, and this may be reiterated later, currently the Judicial Council of California, as well as the Contra Costa County Court, are limiting, their administration of unlawful detainers. So currently, the county, as well as the Contra Costa, Judicial Council, are kind of similarly reflected their change in rules, and they basically said we're not issuing summons for an unlawful detainer unless it's for the public health and safety. So that's a logistical hurdle that you'll have to get past, even if you consider it a breach, and even if you serve a notice right now. There are quite a bit of logistical impediments in front of any attorney that is attempting to go forward with an unlawful detainer right now. That's all.
Thank you both. Okay. The next question is, if the tenant did not pay rent while the emergency order was in place and fails to make payments of the previous rent, but pays the current rent, can I evict this tenant for non-payment of rent?
So the order is pretty specific on what this requires, right? So it was established in March 17th of 2020. And essentially what it said initially was that tenants need to notify the owner of their inability to pay rent due to financial reasons related to COVID. Once the order expires, the tenant will have a year to pay back any unpaid rent. So for example, if I, as a tenant, didn't pay rent April, May, and June, and now the order has been extended to July 15th, then let's say I don't pay rent in July. My rent is due 1st of July, and I don't pay that rent either. Once that order expires, I have a year to pay back that unpaid rent for 4 months. So it's not that the order is going to expire and all of a sudden I need to pay 4 months of unpaid rent plus my current rent. The tenant will have 12 months currently to pay back that unpaid rent. So after, the allotted time of the order is given, and then the tenant hasn't paid that unpaid rent during this whole COVID time, then that's when we'll probably start seeing, failure to pay rent and going through the eviction process in that way. But there's no expectation that the order is going to expire and the tenant's going to have to pay all that unpaid rent at once. They're going to have 12 months. Yes, go ahead.
Oh, I'm sorry. Yeah, I just wanted to add too, the question is saying if the tenant did not pay the rent while the emergency ordinance is in place and fails to make payments of the previous rent. So if that question is saying previous rent like February or something like that prior to the inception of the order, that's an interesting question. First of all, like I said before, the courts have these logistical impediments that you're going to have to deal with as a landlord if you wanted to try to evict. Second, let me just pull up the current order. I'm sorry, hold on one second. So sorry, give me 1 second. So the current order, just on its face, as I read it, says through, well, this is the previous one, but it should say through July 15th, 2020, an owner of residential real property or commercial real property shall not terminate a tenancy for the following reasons: for non-payment of rent, if the tenant demonstrates the tenant is unable to pay rent due to financial impacts related to COVID-19. And that's it. There's no exceptions to that, right? And so if there is some previous rent that was unpaid prior to the order, but you are now trying to terminate a tenancy based on that rent, I don't believe you would be able to prosecute that matter. But that's an interesting question. You may want to speak to legal counsel about that.
Thank you both. The next question is, what can I do as a landlord if the tenant violated the maximum occupancy code? What consequences will this have on my tenant?
I'll answer that one.
Yeah.
We can't tell you what to do as a landlord. That said, though, I mean, if you're thinking that you potentially want to evict because you believe that there are just too many people, I mean, that's an interesting proposal. I have seen most occupancy limitation evictions are based on the lease. And so the lease will usually say, like, it's limited to these occupants, can have additional people, blah, blah, blah. That's a much stronger argument. To use the kind of maximum occupancy code, which is based off of federal regulation, it's incredibly rare. And I've never actually seen an eviction based on that. It's always been about the lease. Yeah, that's a tough one to answer. What consequence will this have on my tenant? I'm not exactly sure what that means. It just depends on what the facts are. If there's a safety issue, that could be an issue, right? If you want to evict, that's clearly is going to have a direct effect on the tenancy. So it just depends on what exactly is happening in the facts of the case. If you have whoever asked that question, if you have additional questions, feel free to email us and we can continue to discuss it.
Okay, great. So our next question is, I just bought a property in Richmond that has been divided without a code permit, and I want to register the property. I'm not sure. I want to register the property and myself. Which of the options in the applications should I select, where it says indicate your property type, multi-unit, 2+ units constructed before February 1st, 1995, single family home or condominium, rooming and boarding house or SRO. So essentially I take what they're asking is, how should they classify the property on the enrollment form if it's been divided into multiple units without a permit?
Yeah, I mean, the dwelling unit question is not a straightforward question, right? Essentially, if it's 2 dwelling units, this is very common in Richmond. If there's 2 dwelling units, meaning there's 2 different tenancies living in 2 separate units, there's 2 separate entrances, 2 separate kitchens, 2 separate bathrooms, 2 separate sleeping facilities, I think there's a pretty good chance that the rent program is going to consider that a multi-unit property, and potentially would fall under rent control. There is an administrative process that the rent program has where the owner can file an administrative determination and someone will go out and see the property if the owner wants to, be absolutely certain. But if you have, a pretty good understanding, like, yes, there was 2 tenancies here, you could always enroll the property as a multi-unit property. Or it most likely will be a multi-unit property, but it's not a straightforward answer because these cases are highly fact-based. So it would require additional information, see pictures, how is a property subdivided. So Palomar wants to add.
No, that's it.
Okay, so I mean, if you want to discuss the matter further, my guess is you're talking about the property enrollment form. Based on the information, I think it will be 2 units, but obviously it's fact-based, so you can always speak further with the counselor and contact us, and we can discuss the matter further, or if you're interested in the administrative determination process, that's also an option that you can move forward with.
Great. Our next question is, if a tenant fails to notify in writing of the hardship due to COVID-19 and doesn't pay rent, can I evict the tenant? What happens if he calls and says he can't pay rent but doesn't submit proof? Does this have grounds for eviction after the emergency ordinance is over?
Yeah, so in order for the tenant to have the protection of the order, they do have to notify the owner in writing of their inability to pay rent due to financial impacts related to COVID. However, they do not have to provide any proof. So if you're expecting the tenant to give you like pay stubs or some letter for the owner, that's not required under the order. So they need to simply, the order allows for text, email, or a letter. So they would need to notify you in writing of that impact. your ability to evict a tenant is kind of unclear right now because the courts are, you know, not processing. I mean, they are, but limited. They're processing limiting evictions. So I don't know how successful you would be. So it says, what happens if he calls and says he can't pay rent but doesn't submit proof? Does this have grounds for eviction? I don't understand. Yeah, go ahead, Palomar.
Yeah, I can answer that last question. So remember that the emergency order allows up to 12 months for the tenant to pay back any unpaid rent that was covered during the order. But I think Magali's correct that in order to invoke its protections, they have to submit it in writing. Now, also as Magali said, you can attempt to evict a tenant in theory if they haven't, you know, submitted any type of written notification of their financial impact. However, as she said, the courts are limiting their summons, their acceptance of filings, and so you really should talk to an attorney prior to taking any further action, because it may just be a better decision to wait until the courts are fully open or until the rules are changed back to normal.
Okay, great. Thank you both. Our next question is, how is the MAR calculated? Is this based on the number of bedrooms and bathrooms, or just based on the original agreed rent amount?
So it's the MAR, so previously explained, the MAR has three components. So there's the base rent, there's the AGA, and additionally, it's if there's a petition process. So the norm, most units are calculated by the base rent plus the annual general adjustment. And the base rent is the negotiated amount that the tenant and landlord agreed the rent was going to be. So the landlord essentially establishes the base rent. So it would be what the landlord was accepting in rent on July 21st, 2015. If it's a newer tenancy after July 21st, 2015, it's what the landlord set their rent to after that tenancy moved in. So that would be the base rent. Then there's the AGA component. So the AGA is based on the inflation rate of the Bay Area. So it's a number that we get on a yearly basis. We don't control it. It's just essentially what the inflation rate is. And it's announced on June 30th of, no later than June 30th of every year. So that's the second component. And like I said, this is what determines the MAR for most cases. Then there's a third component, which is a petition process. So sometimes a landlord will petition for an increase in the maximum allowable rent due to increase in occupants, due to increase in services or space, or due to due to the M&I petition, if they say that their expenses they're not meeting a fair return based on what they were initially receiving from net operating income in 2015. Or the other option is a decrease in the MAR. If the tenant is saying, well, the owner has been charging me excess rent, or I am experiencing a reduction in space or services, or there's habitability issues. Or the third one, the owner has unreasonably allowed me to replace the tenant, which the third section is a little bit more complicated. I think that answers the question. So there is multiple components that go into the calculation of the MAR.
Excellent, thank you. The next question is the landlord rent adjustment petition. What if the occupants were children and now are over the age of 18 years? Is this still applicable?
I can take that one, Magali. So for this type of question, you have to look at some of the regulations. Generally speaking, I mean, again, some of the facts are unclear to me, but if a child, was in the unit when the tenancy first started, well, they're probably counted in what's called the base occupancy level. So if you have a family of 4 and the base occupancy was 4, and now that child is 18, the base occupancy level didn't change. They just got older. And so you actually would not be able to do that based on that fact. Also, in Regulation 903 B2, so the regulation says that no increase in the maximum allowable rent for additional tenants shall be granted for any additional tenant who is a spouse, registered domestic partner, child, grandchild, parent, grandparent, legal guardian of a child, parent of any of the tenants, or caretaker of tenant as required for reasonable accommodation for a person with a disability, unless the tenants agree in writing to the specific maximum allowable rent increase. So again, there's a secondary argument to prohibit any type of rent increase for a child.
Okay, thank you. The next question is, what is the civil code that says a tenant can sue the owner for rent back, to pay back rent if they've lived in a unit that was illegal, meaning built without permits?
I don't know the civil code off the top of my head.
Yeah.
Palomar, I don't know if you know it.
It's actually not necessarily a civil code. I mean, there are civil codes related to this. However, you know, the private right of action and the ability of a tenant to sue the owner is not necessarily based in a civil code only. There's a lot of case law, specifically when you talk about a unit that is illegal and doesn't have a certificate of occupancy. There are cases that talk about public policy considerations when you enter into a contract that was basically unenforceable. Like you rent a unit to someone saying it's a residential unit, but in fact it's an unpermitted garage or something like that. In theory, the contract is void as public policy, and therefore the tenant could sue for all of the damages that they have paid into, which means rent, and any other issues that they may have. But you know, those particular claims and the actual lawsuit, I mean, it just depends on the facts.
Okay, thank you. The next question is it lawful to enter the property for annual safety inspection?
Palomar, if you can take that question.
Sure. So, you know, landlords are, there is a civil code on landlord entry. It's California Civil Code 1954. It does provide for various reasons to enter into a unit, mainly to show the unit to prospective renters or buyers, or to perform necessary or agreed upon repairs. That said, and also even if you, well, no matter what, you still have to provide at least 24 hours written notice. But if the question is an annual safety inspection that you as a landlord just want to perform, unless it's based in the law or some part in the lease agreement, then I don't think you could, right? Because you can't inspect the tenant's unit just generally. If they have an issue or there is some concern for safety that you've heard about, like, I don't know, there's something wrong with the, you know, the fire alarm or something like that, or I don't, I mean, something like that, that's different. But, you know, it's basic, but, oh, I'm sorry. The other part is that if this annual safety inspection is the one from the city, because you have to comply with some of the requirements of the city for the rental housing safety inspection program, I think it's called.
Yeah, that's once every 3 years.
Right, right. I'm sorry. Go ahead, Miguel. Why don't you tell them about that?
No, I was just gonna say that that's once every 3 years if they're not self-certified. So it's not an annual inspection. It's, you know, selected properties once every 3 years.
Right. So I would look at California Civil Code 1954 to determine whether or not you'd be able to enter, and I'll also check the lease.
Okay, thank you. The next question is, will this slideshow be available for download?
Yes, it's actually available right now on our website. If you go to richmondrent.org, and then it's under the workshop section. We have it in English and will be available in Spanish within the next few days.
Great. In a similar vein, there's a question here that I'm happy to answer. It says the workshop was helpful. Thank you for providing this webinar. It's a lot of good information. will this recording be available online afterward? And the answer to that is yes, we are recording it, so we can provide this on our website so that folks can not only see the presentation, but also hear Magali's explanation of the slides. So stay tuned. The next question is, under California Civil Code 1954, landlord lawful entry, can a tenant rightfully refuse to allow entry due to coronavirus-related concerns?
So, yeah, I can answer that. So, yeah, the law, as I previously stated, does allow, under certain circumstances for a landlord to enter, given proper written notice. However, you're right that under that law, one of the reasons to show a unit is to show the unit to prospective renters or buyers. However, clearly right now that's a potential risk and could be harmful. So the Contra Costa County Health Department issued, as part of their shelter-in-place order, they mentioned what is considered an essential business. And one of those is actually, people who are involved in real property transactions, and that includes showing the unit. But they said that, if you have to do it virtually, and if you can't do it virtually, then you have to set it up with the tenant that they're not there while it's being shown. So, I guess it somewhat depends on what what's the reason for the entry. But the best option for this is really to work with the tenants, because clearly, no matter what, if at any time someone enters into someone's home, there's a potential risk, and those risks should be discussed and handled between the parties.
Thank you. The next question is, I have a single family home. How much percentage can I increase on the rent? And if I'm selling the house, can I evict the tenant?
So again, the term single family home, if it's one dwelling unit on the parcel, then it's most likely not regulated by the rent program. There is, AB 1482. So if the property's, own, I think it's like a corporation, LLC, or some type of like real estate group, you might want to look into that law, AB 1482. If you are an individual owner, then it's most likely not, under rent control. Therefore, it's only under eviction protection. So to answer the first part of your question, what would need to be, the only requirement you have under state law are noticing requirements, which is Civil Code 827. If it's less than a 10% increase, it's a 30-day notice. If it's more than a 10% increase, it's a 90-day notice. One thing that we will mention is that there is a penal code. I forgot I have the number. I think it's 3946. I don't know, Palomar, if you know that off the top of your head.
The penal code for what?
For you are not allowed to raise the rent or anything for more than 10%.
Oh yeah, I'd have
during
to
an
find
emergency order. I wrote it down.
Yeah, I don't have it off the top of my head. I think it might be 396.
Yeah, Penal Code 396. So that's the first part of your question. That the rent program, if it's a one dwelling unit on a parcel, we don't regulate it. So you would need to follow Civil Code 827. With everything that's going on, there's additional, laws that are taking in place because there is an emergency order in place. The second part of your question is, if I'm selling the house, can I evict the tenant? And the answer is no. If your reason for evicting the tenant is because you're selling a house, that is not part of one of the 8 just causes for eviction. So to evict a tenant, you need to have just cause to evict. And previously mentioned, the first 4 are at fault evictions, meaning tenant has not paid rent, they're breaching the lease, there's a nuisance, there's a failure to give access, or the other 4 which most of them wouldn't apply, is owner move-in, withdraw from the rental market, temporary termination of tenancy for substantial repairs, or temporary tenancy. So you would need to have a just cause to evict a tenant. You simply can't say, I'm selling the property and here's a 60-day notice or whatever type of notice. So that's really important for owners to understand, and also for realtors to understand, that selling of the property is not just cause for eviction. If you were to sell the property, you might want to sell it with the tenant in it, and then the new owner would inherit the tenancy, or further understand the law to further understand the options that you have if you really want to sell the property.
Thank you. The next question is, in a rent-controlled unit, what if the seller's lease does not include parking or pets, but the tenant is currently using parking and has pets for the past few months? Does the new owner have to allow this, or could this be considered a breach in the lease?
So this is potentially considered a breach in the lease. One of the things that I see happen, it happens pretty often when the new owner has purchased a property, is that the previous owner has allowed the tenant additional services or additional things that were not allowed in the lease. So it's important, how long has a tenant had a parking space and how long have they had a pet? Was there, any other type of agreement or permission given on behalf of the owner that, was allowed for the tenant? So if it's a rent-controlled unit and it's not in the lease, you potentially have two options. So one would be to file a petition for an increase in rent for the parking space, because you're providing an additional service, or potentially seek a breach of the lease. This question is like heavily fact-based, so we would need to know more information on the case to, I think, provide like a more detailed advice. And I think it would also depend on what the previous owner was doing, because I see this happen often where like the previous owner might be managing a different way, and then sometimes allows the tenants to do things that's not on the lease, and the new owner is kind of like, well, this isn't the lease, but the tenant says, well, I've had a dog for 10 years. Like, I've had that parking space for 10 years. So the idea behind that is that, the owner has essentially changed the lease when, they verbally allow the tenant to have these additional services. I think, I don't know if Palomar wants to add some detail.
Yeah, I mean, I was just going to agree that, some of the facts are unclear, but again, kind of harking back to my original answer about pets, first of all, make sure it's not an emotional service animal or support animal or a service animal. And second, yeah, there could be subsequent agreements from the tenant and the owner that are not in the lease that would be enforceable. So if a landlord or tenant asks, hey, can I get a pet? I know the lease says I can't. And then the landlord is like, sure. And he sends it in writing. I mean, there's not much of an actionable issue there because the landlord at the time offered written consent. So I guess some of the facts, are in question. And then, again, it's not up to us if this is considered a breach or not. That's always up to the court. So you'd have to, argue your case in front of a judge.
Okay, thank you. The next question is, if an unpermitted converted garage is being rented and the new owner no longer wants to continue renting due to the illegal conversion, how can the new owner terminate the tenancy?
Well, in order to terminate tenancy, you need to have just cause to evict. So I think this question kind of goes back to understanding when you're purchasing a property, what it is that you're purchasing, and you're inheriting everything that is occurring with the property. And so even if the unit is unpermitted, once you purchase that property, you're inheriting that tenancy and you're inheriting that responsibility. And so the tenant will most likely have eviction protections at the minimum if the unit isn't considered under rent control. So if you want to evict or terminate tenancy, you will need to have just cause to evict.
Could they withdraw one of the units from the rental market, or is there is there a no fault eviction that could be conducted?
Yeah, I guess so. I mean, it'd be an interesting proposition to.
Well, to withdraw,
envelop.
they can't withdraw one of the units. They would need to withdraw all of the units on that property.
Right. It would be all of the units, but yeah, in theory, that's possible. But you'd have to pay the relocation payments to the tenant as required under law.
Yeah, and I mean, it's a just cause for eviction. Withdraw from the rental market is a just cause for eviction, but I think what happens a lot when purchasing properties is kind of like the owner thinks that they can just evict the tenant. They can just issue a 60-day notice. And I think that's one of the important things that I'm trying to get across in this presentation, is that the owner needs to have just cause for eviction. Like, you need to understand, like, when you're purchasing property, you're inheriting everything that is occurring with the property, even if it's legal or not. You're potentially inheriting excess rent. You're potentially inheriting tenancies that, don't have permits, or units that don't have permits, or these fees that haven't been previously paid. So it's extremely important to understand what is going on with the property and to understand the local law, because you're inheriting these responsibilities, you're inheriting these tenancies, and all of the consequences and benefits that come with it.
Thank you, Magali. The next question is, what happens if during the 12-month period the tenant has to pay the unpaid rent? So this is during the COVID crisis. He pays current rent but fails to make payments on the late rent on a monthly basis. Can the tenant wait for 11 months before making payments for the unpaid rent?
So I think the answer is yes, if I understand the question correctly. The tenant has 12 months to pay back the unpaid rent that they didn't pay during the emergency order. So I understand that might be frustrating for landlords. I might recommend that you try to set up a payment plan or try to have a discussion with the tenant, because obviously it's not convenient for the tenant, or it'll be a huge burden for the tenant for if they have like 3 months of unpaid rent and then they try to pay all of it on that 12th month. It probably won't be reasonable for them to pay all of that. So obviously we would encourage tenants and landlords to try to come to a compromise and an agreement to try to work together, on a monthly basis. They pay a chunk of that unpaid rent. But yes, the tenant could do that. They could wait, the entire period, and then last minute or before the tenant has 12 months to pay back any unpaid rent. So hopefully that answers the question. Sometimes I don't know how clear I am when I'm answering these questions.
I think that was pretty good.
Okay.
I agree. I think that, the order doesn't say anything about they have to pay, every month for the unpaid. It just says they have 12 months. So in theory, yes, they could wait, but then they would have all this money due on that last month, and then right after that ends, then they would be forced to probably deal with an eviction.
Yeah. So I think compromise is encouraged, or cooperation is encouraged for that situation.
Great, thank you. The next question is, if the tenant subleased the property when the lease states that there's no subleasing allowed, can I evict the tenants due to this reason?
It might be a breach of the lease. Again, that would be the rent program doesn't determine, if this is an eviction, if this is a cause-worthy eviction or not. We simply administer the process and ensure that the administrative process of the ordinance and the requirements of the ordinance are being followed. So if you think it's a breach of the lease or the tenant is subleasing, I would encourage you to speak with the tenant. Obviously, the tenants under the ordinance have a right for a replacement. So if someone has moved out, they have a right to replace that tenant under the ordinance, and it wouldn't be considered a breach of the lease under those circumstances. But if something else is occurring where, the tenants that are still that you allowed are still living there, and plus they've subleased to someone else, you would first need to issue a written warning notice, explain the circumstances. If the tenant doesn't comply or you don't hear a response, then you would need to issue a termination of tenancy for breach of the lease, and then eventually, you know, file an unlawful detainer in the courts. Currently, unlawful detainers are, you know, are limited. So it's unclear how successful you would be. And ultimately, if it does go through the unlawful detainer process, it would be up to a judge to decide whether that is a breach of the lease and a reason for the tenant to lose possession of the property.
Yeah. Oh, I was just going to add a small comment. Yeah, I mean, if it's a true sublease, and in fact the lease does prohibit subleasing, just period, then it's a potential breach. However, you know, as stated previously, the courts right now are really difficult, and they're not going to be issuing a summons unless it's for the public health and safety. You know, I think the more appropriate question is, can I attempt to evict the tenant due to this reason? Sure. You know, no one's stopping you, but whether or not you succeed is the question, and I can't make that determination.
Thank you. The next question is, thank you for attempting to answer the question about California Civil Code 1954 and the tenant refusing entry. It is still unclear if the landlord has a valid, lawful reason to enter the property and gives proper notice and the tenant refuses entry. During the main presentation, I believe it was stated that the tenant's refusal to allow entry could be a just cause for eviction. Relatedly, can a tenant rightfully refuse to allow entry due to his or her coronavirus-related concerns? Or would that tenant be subject to eviction if she or he continues to refuse landlord entry?
I think that's a follow-up to the question that was answered earlier. So I apologize if I didn't answer the question completely. So if the landlord has a lawful reason to enter and gives proper notice and the tenant refuses, yeah, you're correct. Generally speaking, if you follow the law and the tenant just says, I don't want you in here, and they just don't provide any reason, that could be a potential just cause for an eviction. However, as I said before, it depends on what the reason is for the entry, because nowhere in this question do I see why you want to enter. If you want to enter to show the unit, you have to follow the guidelines produced by the Contra Costa County Health Department. However, if it's to, you know, perform some repairs, then you don't. And so it really depends on what, you know, the issue is. And then can a tenant rightfully refuse to allow entry due to his or her coronavirus-related concerns? Yes, because again, the order says you can't do that. You can't enter into any tenancy to show the unit right now due to the current health order, because there's a risk to their health. Now, the larger question, or would the tenant be subject to an eviction if she continues to refuse landlord entry based on, you know, given the current status and the pandemic? I don't know. That's a hard question to answer, because, you know, it's up to a judge to decide, well, what are the risks involved with this, you know, person wanting to enter, and is that sufficient to move forward an eviction? I don't know, because again, the court's rules have changed. They're just not issuing summons unless it's for the public health and safety. So to say, well, I want to enter and they're not doing it, I don't know if the court would even, you know, allow that eviction to move forward right now. I hope that answers your question, and I apologize if I didn't answer it earlier.
Okay, thank you. Our next question is, are air filters landlord's responsibility? Does this have to be put on the lease?
I don't know the answer to that off the top of my head. I would need to do further research.
Yeah, that's an interesting question. I mean, generally, whatever is provided to the tenant, the landlord has somewhat of a duty to maintain, unless the tenant is at fault or their guests somehow messed it up, right? So, you know, a simple one is like, if you choose to provide an oven or refrigerator, and just by happenstance that fridge or oven just breaks down through no fault of the tenant, you would likely be responsible to maintain those amenities that you provided. Because, and again, some of this depends on the status of the unit. The tenants, if they're fully rent controlled, they could theoretically file a petition to reduce their rent based on a reduction in housing services. And then to your second question, does this have to be put on the lease? No. You could, I think, put it in the lease to say, you know, I provide an air filter, but a replacement of it is your responsibility. You know, I don't see any potential illegality on that, but you would have to, you know, clearly state that in the lease.
Okay. Thank you. We have about 5 minutes left and we have 2 questions remaining. The second to last question is, can you withdraw illegal converted garage from the rental market?
So the withdrawal from the rental market establishes that an owner could withdraw from the rental market if they no longer want to be in the rental business, but it would have to remove all of the rental units on the property. So you wouldn't, if you rent out the main house and the back unit is, the back garage is converted and that's also a unit, you can't just say I'm withdrawing the garage, but I'm not withdrawing the main house. So that's one thing, is you would need to withdraw all of the rental units on the property. The withdrawal from the rental market is, I think, an extreme situation, or I think one of the most extreme eviction just cause for evictions. It's a state law. It's known as the Ellis Act under the state of California. It has a lot of restrictions, and the idea of it is saying, the owner saying, I no longer want to be in the rental business, so I'm withdrawing this property from the rental market. And the consequence of that is that the tenant is evicted because that property is no longer going to be in the rental market. The tenant would have minimum of 120 days notice if they are, if they have children, if they're considered low income, if they are, I think it's if they're disabled or considered a low income household. I might need to.
Yeah,
check.
that's right.
That's correct. Okay. They have up to a year to remain on that property. There's also a relocation payment that would need to be paid, which I think is, I don't know the number off the top of my head, but it's in the tens of thousands. So I think it ranges from like 14 to 19,000. I don't know if somebody wants to research that. So you're potentially looking at 2 units. So it's not like a simple, I'm just going to withdraw from the rental market because this is a legally converted unit. It's a pretty complex process. It also changes the title of the property. You would need to change the title with the county. It puts rental restrictions on the property for up to 10 years. It follows the property, not the owner, because it changes the title. So it's a pretty complex process. And I would highly recommend that you consult with an attorney. Most attorneys offer free consultations. You can just look up landlord attorney in Richmond and, try to get a free consultation. There's also Bay Area Legal Aid. They have the clinic on Mondays from 9 to 12. So you can contact the rent program or look on our website for the information. Yeah, because that's a complex situation. I don't think the withdrawal from the rental market is necessarily the best course of action.
Yeah, I would agree with Magali. It's a heavily regulated, very complicated law. And the only thing I wanted to add was that when you perform an Ellis Act eviction and you withdraw, you are strictly prohibited from renting it for 2 years solid. There are different restrictions for 2 to 5 years and then 5 to 10 years. But for those first 2 years, if you rent the unit, any unit that was removed from the market, that tenant who was evicted would have a private right of action against the landlord for a wrongful eviction. And they could sue that landlord for a substantial amount of money. So, this is not really a good just cause just to evict a tenant. It's a heavily regulated law that has long-standing repercussions for years after you perform the eviction.
Thank you. I think we have time for one more question. And this question is, can a payout be negotiated between a tenant and landlord on an illegal garage conversion?
So I think this is kind of like a buyout question. So currently the city of Richmond was considering establishing regulations for the buyout agreement, which essentially is the owner is offering some type of sum for the tenant to voluntarily vacate, which is allowed. There are no laws that restrict this, but the rent program doesn't oversee this, and we currently don't provide any form of structure for it. The rent board has considered regulations and put forward their recommendations, but it hasn't been officially approved by city council. So we can advise on it. You can consult with an attorney. One thing that I would say is that if a buyout agreement is established and conducted between landlord and tenant, and it's not followed, it's not a just cause to evict. So I've seen this happen before where, you know, the tenant and the landlord agree on some type of sum and some type of move out date, and then the tenant can't find a place or is kind of like, oh, actually I checked with the rent program and the relocation payments are much higher, or any type of reason. It's not a just cause to evict, and you would need to sue the tenant, you know, through some other means, because a voluntary buyout is not just cause for eviction. So you would need to consult with an attorney on that. We currently don't have any further regulations establishing laws or structure around the buyout.
Okay, thank you. If you did not get your question answered, I would encourage you to copy and paste your question into an email and email it to rent@richmond.ca.us. Our contact information is on the slide above. Again, apologies if we did not get to your question. You can send us an email and we can have a one-on-one consultation with you. So with that, thank you all so much for attending, and we hope to be in touch further.
Thank you, everyone, for attending.
Thank you.